I wanted to review some case law, and this one here is Roundtree Beach Association. The Attorney General's office felt that in this community of Tiny Township, Penetanguishene area, that the Attorney General's office, the province, owned the beaches of these lots, of actually Lot 18. One of the interesting things that the judge made comment is that there's a reservation for all persons, vessels, free access to the waters of Lake Huron. And he made that statement saying that if the Attorney General's office owned it, if the province owned the land, then why would there be reservations? So, in conclusion, the judge made this statement. As to the defendant's counterclaim, the defendants are entitled to the following, and that is to say, a declaration that the owners of blocks A and B of each individual lots 1 to 45 inclusive, registered plan number 750, registered in the registry office for the registry division of Simcoe, own and have title to the water's edge of Nottawasaga Bay, subject to the right of free access to the shore of Lake Huron for all vessels, boats, and persons, and that Her Majesty, the Queen in right of Ontario, has no right, title, or interest in and to the lands described as blocks A and B and each of the individual lots 1 through 45 inclusive. Registered Plan 750, save free access to the shore of Lake Huron for all vessels, boats, persons from Lake Huron. So that came from the patent, that decision. So if we continue on, it reminds me of what the judge is looking at, and that's the Evidence Act. And it says here, again, I'm going to be repetitive, that letters patent under the Great Seal of the United Kingdom and any other of Her Majesty's dominions may be proven by the production of an exemplification thereof or an enrollment thereof under the Great Seal under which such letters patent were issued, and such exemplification has the like force, that means it's the same as the original letters patent, and effect for all purposes as letters patent thereby exemplified or enrolled, as well as against Her Majesty as against all other persons whomsoever. Now, we're going to just go to Chitty here, and Chitty makes some very good descriptions and analysis of what Crown law is. And letters patent are under Crown law. Letters patent under the Great Seal are matters of record and are therefore read without proof. And by statutes S and 4 of Edward VI, chapter 4, and 1 and 3 of Elizabeth, chapter 6, patentees and all claiming under them may make title by showing the exemplification or constant of the roll. These statutes have been held to the extent to all the king's patents which concern lands, privilege, that would be right, or other thing granted to a subject, corporation, or any other. The perpetuity of a crown is to be expressed in the quaint maximum that the king never dies, by which it is meant that on the death of the king, the prerogatives and politic capacities of the supreme magistrate instantly vest without a moment's intergram in his successor. And that reminds me of the Legislation Act, which talks about succession. A change of reigning sovereign does not affect anything done or begun under the previous reigning sovereign, and all matters continue as if no succession had occurred. Some food for thought.